BSI was having difficulty selling brown sugar into Trinidad because it couldn't meet the prices that the purchasers in Trinidad insisted that they could get brown sugar for. The prices were very low. And this was the first signal, because BSI took the position that there was no way that anybody can sell brown sugar cheaper to Trinidad if the CET was being charged than the prices they could offer. So that they were of the view that whatever was happening there, it was causing a market distortion on the ground that was driving the prices so low that not even BSI, whose sugar is not subject to the CET, could compete. So they conducted investigations, and they were able to uncover a number of shipments leaving from this region, Honduras, Guatemala, and heading for Trinidad. But the information didn't have the particularity, nor were we able to get the primary sources of that information before the court to testify to it. It's a difficult proposition. You see, all the documentation evidencing the importation would necessarily be with Trinidad. They know what they did, what was imported when, and what the documentation is. So we had sought, based on the preliminary information, to get orders of disclosure from the court to force Trinidad to turn over documents that they had to show that what the circumstantial evidence showed was happening, which is that that brown sugar was being imported without charging the CET.
And how did that play out? Were those documents released?
No, what Trinidad did was simply to go on its Asikuda system and print off all the invoices, all the entries for brown sugar, and all of them necessarily showed that the CET was charged. You see, the charges in the computer system are automated, so once they're there, it means it was charged. The ones that concern us are the ones that are not there.